hopefully all of you are keeping very well during these times of very tough times, especially for the advocate fraternity. Without wasting any time and coming, can you all hear me? Am I audible?
Yes, ma'am, you are audible.
Okay. So today, coming straight to the topic, anticipatory bail. So what is the anticipatory bail? Anticipatory bail, as the name suggests, is bail in anticipation of arrest. This word, if you go through the entire CRPC, this word does not find mention anywhere. This word was first coined by the 41st Law Commission report, wherein the provisions for the first time of anticipatory bail were introduced. What the 41st Law Commission report was introduced on 24/9/1969, and para 39.9 gave the justification for the introduction of bail. Why was there a need for anticipatory bail? The need for anticipatory bail arose because first there was politically rivalry amongst people. They used to falsely implicate each other. Second, the need arose because the parliament thought that if a person is not likely to flee from justice or is not likely to tamper with any evidence, there is no point keeping that person in custody. So therefore, the provisions of anticipatory bail were introduced. In fact, one of the very interesting things, while introducing the provisions of anticipatory bail, the Law Commission very carefully looked at all the parameters of section 437 and 439 and said that we are not including the conditions imposed under section 437 and 439 in the conditions under section 438, that is anticipatory bail, because if we impose some conditions, it would actually amount to prejudging the entire trial and prejudging the entire case. Therefore, what they said was that we don't want to put any conditions, and they introduced the concept of anticipatory bail. Interestingly, they also gave this power only to the High Court and the Sessions Court because they felt that the discretion will be correctly exercised if the power is given to them, and there will be no need to impose any restrictive conditions. So therefore, this provision came into being. All of you would be interested in knowing as to who is entitled for anticipatory bail, what is anticipatory, stage can we apply for anticipatory bail. So anticipatory bail can be applied at any stage. It can be before the registration of an FIR, it can be after the registration of an FIR, it can be before the filing of the charge sheet, and even after filing of the charge sheet. What has to be there is a reasonable belief that there is a fear of being arrested. Mere apprehension that we will be arrested is not enough. It has to be based on certain correct provisions, or it has to be based on certain documents which the court is able to analyze, and then the provisions of anticipatory bail can be applied for. Now, reason to believe has been discussed in a lot of judgments. It has to be substantive. It has to be based on documents. It has to be based on the fact that the court can examine the reason to believe. If that is not there, mere fear or mere fear would not be sufficient for applying of the anticipatory bail. Now, one of the most important cases in anticipatory bail is Gurbaksh Singh Sibia versus the state of Punjab and Haryana. I will just point out the citation for all of you who are interested. I will also be sharing a link of that judgment. So it was a judgment 1980 to SCC 565. Now this judgment arose from an order of full bench judgment of the Punjab and Haryana High Court. In the full bench judgment, the Punjab and Haryana High Court, while rejecting the bail application of the applicant, stated certain provisions. What were the provisions and their own interpretation of section 438? They gave a very restrictive interpretation to this provision. What did they say? They laid down 8 points. The first point being that the power under Section 438 is an extraordinary power and it should only be applied sparingly, only in exceptional cases. Second, neither Section 438 or any provisions of the code authorizes the grant of blanket anticipatory bail. That is, which means that what is a blanket order? It means that anticipatory bail can be applied only for the offenses which are mentioned. It is not a blanket order that once I apply for anticipatory bail, I will be immune from all the other offenses that I commit in the future. Third, that the power is not unguided or not uncanalized, but limitations which are mentioned in Section 437, which is the provision for an ordinary bail, are also implicit in Section 438. In addition to the limitation mentioned in Section 437, the petitioner had to make out a special case. That is, in fact, imposing even more conditions than imposed in Section 437, therefore making it more difficult for the litigant to apply for anticipatory bail. The sixth point was that discretion under 438 cannot be exercised with regard to offenses which had life imprisonment or with regard to death. The seventh condition which was laid down by the Honorable High Court of Punjab and Haryana was that the larger interest of public and the state demands that cases involving, say, blatant corruption or political power, in such cases, anticipatory bail should not be granted. And the final condition that they imposed, or the final interpretation that they gave to the provision of Section 438, was that mere allegation and the malified in the petition are inadequate. The petitioner must be satisfied in materials before it that the allegation and malified is substantial. And there appears, so an extra burden was put on the applicant that you please prove that the allegations in the FIR are false. Now, in view of this, the matter went to the Supreme Court. The Supreme Court constituted a 5-judge bench. In that, they gave the interpretation of Section 438, which was one of the most celebrated cases in BAKSH Singh Sibia. What was held was a very large interpretation was given. It was said that when the legislature did not intend to put any embargo on the discretion which is given to the courts under Section 438, we cannot read any further conditions. In fact, if you remember, I just pointed out that the Law Commission very clearly stated that we do not want to impose the conditions which were imposed in Section 437 and 439 under Section 438. And we want to give the discretion to the high courts. So therefore, those conditions, so reading certain additional conditions which are not even intended by the legislature are not correct. And therefore, the Supreme Court overruled the judgment of Punjab and tell as to what exactly its section, what is the embargo of Section 438. It stated that the opinion of the High Court that it has to be construed narrowly and conditions imposed in Section 437 are to be read are incorrect. Second, it held that it is not correct that in cases of death and life imprisonment, anticipatory bail cannot be given. It further held that a person, for example, if all of you would be aware of Section 27 of the of the Evidence Act, which says that if a discovery of a document is to be made, then generally what the police used to do was the police used to say that we have to recover something from the accused person. So therefore, he should not be given anticipatory bail. The court said that you can take the person into custody for a limited time. There is no need to reject his anticipatory bail only because that certain discovery under Section 27 has to be made. He can surrender for a limited time. You do your discovery, you conduct your investigation, and thereafter you can again release the person. And why do you want to put that person's liberty at stake? So therefore, a very, very wide interpretation was given to Section 438 and wide discretion was given to the Court of Session and the High Court with regard to anticipatory bail. Now we come to the case in hand, that is Sushila Aggarwal. Why was this reference made? So the reference was made in 2018. Because as all of us know as lawyers, it's very, very difficult to get anticipatory bail. And if you're a criminal lawyer, everybody knows that all your clients want is bail. So if you are able to secure that And the courts have given a very restrictive view, especially if you say if there is an offense of cheating or criminal breach of trust. The courts are very, very reluctant to give anticipatory bail. So what happened was, there were various contradictory views. The first contradictory, there were two lines of judgments which were there. The first line of judgments gave a very wide interpretation to Gurbaksh Singh Sibia and said that according to Gurbaksh Singh Sibia, there are no fetters on the power of anticipatory bail. And the court can grant anticipatory bail for unlimited period of time. Which were the judgments, those line of judgments were Sitaram Mehra, and which is of a 2011 judgment of the Supreme Court. And the second line of judgments was Salahuddin Sheikh, Sunita Devi, Aridharan Das, HDFC Bank Limited. These line of judgments stated that various conditions were imposed. Those conditions were in time, in view of, say, time, or upon the happening of a certain event, say the filing of a charge sheet. It was stated that upon the happening of such an event, the anticipatory bail will either come to an end, or you will have to go and surrender before the court, the trial court, and seek regular bail. Now, in view of this, the reference was made to the Supreme Court of India. There were two questions which were answered by the Supreme Court of India. The two questions were that whether the protection granted to a person under Section 438 should be limited for a time period fixed to enable a person to surrender before the trial court and seek regular bail. And second, whether the life of an anticipatory bail should come to an end and a stage where the accused is summoned by the court. So these were the two questions which were to be interpreted, which means in effect that whether, as all lawyers would ask, as to whether the anticipatory bail comes to an end, does it last for the entire trial period? Or after the filing of a charge sheet, or say the accused is summoned before the court, or after the framing of charge, the anticipatory bail will come to an end. So these were the two questions which were referred. The Supreme Court gave a very wide interpretation and stated that first, the protection granted under Section 438 cannot be limited for a time period, unless and until there are certain conditions which the court itself imposes. And why will the court impose those conditions? The court will impose those conditions in certain circumstances, looking at the facts and circumstances of each case. If the court feels that there is a need to apply, or there is a need to impose a condition, then only in those cases, conditions should be imposed. Ordinarily, the court should not put a condition that it should be imposed for a certain time period. The court should not impose a condition that it should be only limited to, say, 4 weeks and thereafter you go and surrender. However, if the case and the facts and circumstances of the case warrant that anticipatory bail should be limited, the courts can do so in its discretion. The second question was whether the life of an anticipatory bail should come to an end at the stage when the accused is summoned by the court. The court said, ordinarily, the anticipatory bail will not come to an end or will not terminate automatically after the filing of the charge sheet or after the accused is summoned. It will ordinarily last through the entire trial, unless and until the court in its discretion had applied its brain and said that no, given these circumstances, given the history of the accused person, you have to impose those conditions, and it will only be given for a limited period of time. Only in those cases, the charge sheet will come to, the anticipatory bail will come to an end before the trial is over. The more interesting point in this judgment that the court also stated was that the court also stated, as I talked about Section 27 of the Evidence Act, that in case the police wants to conduct any investigation, it should not say that, anticipatory bail should not be given. The police can go and the accused can voluntarily surrender and conduct the investigation, and thereafter the person should be released again. Now, I will just point out as to what are the other factors which the court also stated that should be kept in mind while granting of the anticipatory bail. It said that what the factors which are to be considered are that what is the nature of the offense? Does the accused have any history of this thing? The court also stated that no blanket order should be granted. Blanket order would mean that, as I pointed out earlier, that reason to believe is very important. In your bail application, you will have to state the reason as to why you feel that you are apprehending arrest. If that is not stated, then your anticipatory bail is not tenable. So therefore, the court said that when it is based on certain apprehension, then it will only be given for those offenses. It cannot be a blanket order covering everything and for any other future offense. Such an order would be bad in law. In fact, it will become a tool for abuse at the hands of the applicant, that once I obtain an anticipatory bail order, I am free to commit any other offense in the future. Moreover, the order of anticipatory bail does not limit the power of the police to investigate. Then this question arises that, for example, an anticipatory bail is granted. Now, can you challenge it before a higher court? The correctness of the anticipatory bail order. This judgment very clearly stated that you can challenge that order at a higher court if you feel that the order is bad. It can be done either by the investigating agency or by the police authorities. If they feel that the order is bad, then such an order can be challenged. The court also, while passing this judgment, overruled the interpretation given in both line of judgments, which was a very wide interpretation which was given in Mehra, that there are no conditions which are imposed. Second, it also overruled the judgments in Salahuddin Sheikh, which was a 3-judge judgment of the Supreme Court, which stated that it is only for a limited time period. The court said that both the interpretations are incorrect. Neither a very liberal interpretation can be given, neither a very restrictive interpretation can be given in view of the Gurbakhsh Sibia judgment. What has to be seen in an anticipatory bail is that the person's life and liberty is balanced with the police's power to investigate. So there has to be a very fine balance between the two. Because anticipatory bail stems from Article 21 of the Constitution regarding a person's life and liberty. So when you're talking about a person's life and liberty, that has to be taken into consideration, but it also has to be weighed in view of the power of the police to investigate. The state has the power to conduct investigation. So therefore, there has to be a very fine balance, and that is the discretion which is given to the High Court and the Court of Session to see in the facts of each and every case as to what is that fine balance and how that fine balance would be maintained. Now I will just tell you as to what were the concrete points which were laid down by this judgment. So the first question, which was regarding whether Section 438 is limited to a certain time or to enable a person to apply before the court, it was held that the protection granted under Section 438 should not be ordinarily limited to a time period fixed. It should incur in favor of the person accused without any restriction as to the time. Usual and standard conditions under Section 437(3) read with Section 438 should be imposed. If there are peculiar features in regard to a crime of an offense, such as the seriousness or the gravity, etc., it is open to the court to impose appropriate conditions, including fixed nature of relief or it being tried in an event, etc. The second point was answered stating that the life of an anticipatory bail will not come to an end at the time and stage when the accused is summoned by the court or after framing of the charge, but can also continue till the end of the trial. However, if there are any special or peculiar features necessitating the court to limit the tenure of anticipatory bail, it is open for it to do so. The court also clarified the guiding principles which were laid down in CBR. It held that when a person apprehends, arrests, and approaches a court for anticipatory bail, his apprehension has to be based on concrete facts relatable to a specific offense or of a particular offense. Application for anticipatory bail should contain clear and essential facts to the relating to the offense and why the applicant reasonably apprehends his arrest. It is necessary to impose that condition. The court also held that before an application under Section 438 is filed, depending on the seriousness of the threat, as a measure of caution, may issue a notice to the public prosecutor. One very important point which comes is whether notice is to be issued to the public prosecutor or not. The court stated that depending on the measure of threat, for example, a person is being arrested tomorrow or not, an interim order can be passed, but notice is to be given to the public prosecutor, and only an interim anticipatory bail is to be granted before the hearing of the public prosecutor. The court also said that Section 438 does not compel or oblige the courts to impose conditions limiting the relief upon time of filing of the FIR, recording of the statement by the police, etc. The court, while considering an application, has to consider the nature of the offense, the role of the accused person, his likelihood of influencing witnesses, his tampering with evidence, his likelihood of fleeing away from justice, the necessity to impose these conditions, for example, with regard to time or with regard to, say, certain other conditions. The court has to weigh these circumstances. The court has to see all the above stated circumstances and nothing else. The court has to generally be guided by the gravity of the offense and the role attributed to the applicant. What has to be seen is that whether he played a very active role or he did not play a very active role. Also, the court can, depending on the nature of the offense and also the behavior of the accused, whether he was evading arrest, whether he cooperated with the investigation or not, can give the bail till the end of the trial or can limit it. So that is the condition which has to be weighed before the grant of, before seeing what for time period anticipatory bail will be granted. It is open to the police or the investigating agency to move to the court concerned, which granted anticipatory bail, that for the arrest of the accused under Section 439(2). For example, the accused is not complying with certain conditions and anticipatory bail is granted to him. The court, the police or the investigating agencies can move under Section 439(2) to the court, saying that the bail which has been granted now he's violating those terms and conditions, or he's trying to induce certain witnesses, and therefore the court can cancel his bail in those circumstances. The correctness of the bail order can also be considered by the appellate or the superior court at the behest of the state or investigating agency, and can be set aside on the ground that the court granting it did not consider material facts. However, stating all of that, the conditions which were laid down in MEHRA cannot be imposed. And it cannot be a general rule that you only grant anticipatory bail for a certain limited period of time. You have to generally, ordinarily give anticipatory bail for till the end, as stated earlier. Can the anticipatory bail be restricted? So this, in conclusion, it can be said that anticipatory bail is a provision which has very wide powers. It can be stated that it is ordinarily granted.
Priyanka, we cannot hear you.
Hello? Hello?
Priyanka, there is some, yeah, I just checked, there is some technical issue at your end. We are not properly hearing you.
Do you want me to reconnect? Hello?
Yeah, no, not to reconnect, just to read from the last thing which you had just said. You know, we just all skipped all that.
NITESH, from my end, it is audible. I didn't.
Can you hear me?
Problem.
Yeah, now we can hear you.
So, in conclusion, I will say that anticipatory bail is not limited for a time period. It is not only till the time of filing of the charge sheet. It can ordinarily and it should be ordinarily granted till the end of trial. Second, conditions should only be imposed given the facts and circumstances of the case. It is not correct to say that it is an extraordinary power which should only be used in sparing case at all to impose those conditions. If the legislature, can you hear me? Hello? Hello? Hello?
We can hear you. You may continue.
Yes. So, the conditions are very wide. If the legislature intended to impose those conditions, then in such a case, the legislature would have incorporated the provisions of section 437 or 439. They had those already with them. The reason that the legislature did not include those provisions or those conditions was it wanted to give very wide discretionary powers to the High Court and the Sessions Court. The reason that the power was given to the High Courts and the Sessions Court and not to the Magistrates Court was because they felt that the discretion would be exercised properly. And if we will impose conditions, then it would not be, it would disturb that fine balance between a person's life and liberty, and subjecting somebody unnecessarily to undergo imprisonment even for 2 days would not be correct. Now I'm open to any questions which anybody would want to ask. Hello? Tanu?
Thank you, Ms. Sinha, for this very insightful session. What we can do is, you can share your email ID, and the participants, if they have any particular question, you can answer them separately. Is that convenient for you?
Yes, I can absolutely do that. I'm just sharing my...
So, ma'am, the voice...
Hello?
Hello?
Yes, I will share my email ID with you, Tanu, or I will share it just on the group.
You can share it on the group, and if it's convenient, then we can take it up separately. You can answer this over the email.
Okay, perfect.
And we have one question which I just flown in. This is from Mr. Himanshu.
Yes.
Just 1 second, sorry. It says, where does one challenge the bail? I believe it is, the question is, where does one challenge the bail? And it's still writing. It says, I'm just hearing her over in revision or by any other channel. So the question is, where does one challenge the bail, in revision or by any other channel?
So what happens is, once if you want to challenge the correctness of the bail order, so if you got an anticipatory bail from the High Court, then you challenge it before the Supreme Court. If you've been granted anticipatory bail by the Sessions Court, then you challenge it before the High Court. So depending on where the anticipatory bail or which court granted your anticipatory bail, it would be challenged accordingly.
All right. So, Ms. Sinha, what we can do is, for now, questions are randomly flowing in. So there's another question by Mr. Arun Satijia. It says, can transit anticipatory bail be granted by court?
So transit anticipatory bail can be granted by the court, but it would again depend as to, you will have to explain the apprehension of arrest as to why are you applying here and why are you not going, because the court might very well tell you to go to that state and apply for anticipatory bail. So in certain cases, you can absolutely apply, but you will have to again weigh the facts and circumstances of the case.
All right. Another question. What was the need for Sushila Aggarwal when CBI had laid the law?
Because there were two judgments. The first line of judgment of Sitaram Mehra, which stated that there can be no conditions imposed on bail at all. Then there was second line of judgments, which were HDFC. The HDFC judgment stated that conditions are to be imposed. So in view of two conflicting decisions of the Supreme Court, the need for interpretation or the need for clarification came, and therefore the Constitution Bench was constituted.
All right. I'll be taking up another question by Mr. Himanshu. It says for all cases under SC, ST Act, disentitled for anticipatory bail. What is your view?
So SC Act is a special provision. So obviously a special provision overrides the general provisions of law. So that is a different topic. If we'll have to, it'll be a lengthy discussion on that, because a special, all of us know that a special enactment always overrules a general enactment. So CRPC being a general enactment and SC/ST being a special provision would have the overriding powers.
Right. There is another question. There's actually a request by Ms. Shivani Ghosh, and she says, my question is, please ma'am, where are the major judgments that you mentioned? I think that can be shared separately.
I will just share them here. I will just share the three judgments which I was talking about, and also the report of the Law Commission.
Can we take up the next question?
Yes, just give me 1 minute, please.
Right.
I've shared the judgments as well as the relevant part of the Law Commission report.
Tanu, we cannot hear you.
Hello?
Tanu, we cannot hear you.
Can you hear me now? Am I audible?
Yeah.
All right, I'll continue. Now, the next question is by Mr. NITESH MEHRA, the organizer himself. So,
Yes.
What is the duration of the anticipatory bail? We just missed that part. So, can you please tell us what is the duration of anticipatory bail?
The duration of anticipatory bail ordinarily is for the entire trial period, right? Only in special circumstances, if the court feels fit, it can state that it will be limited to a certain time period. Ordinarily, no such limitation is to be placed.
So what can be those special circumstances under which the court can limit the bail of anticipatory?
Ms. Sinha, are you?
Priyanka, the speaker can hear me?
Hello? Hello, yes, I
Yeah.
can hear you. Yes. So those special circumstances can be the nature of the offense. So as I pointed out earlier, very wide powers have been given to the High Court and the Court of Session. And only in special circumstances they can impose those conditions, which can be, say, the nature of offense, or the person has previous convictions. All those factors have to be taken into consideration. But the interpretation which was given earlier, that ordinarily you should only give it for a particular time period and ask the accused to go and surrender before the trial court and apply for bail afresh, is not the correct view. You have to justify it by reasons as to why are you limiting it to a certain time period. Ordinarily, you should give it for the entire trial, and you cannot impose those conditions as we've seen generally happens.
Right. So
thank you so much, Priyanka, for this. Tanu, if there is any other question, you may take up with Priyanka.
Right. So the next question is, what in case of harassment by police authorities in the name of investigation during the period of anticipatory bail is granted? I'll just repeat the question. It says, what in case of... Right.
Yes.
I'll just repeat the question. It says, what in case of harassment by police authorities in the name of investigation during the period of anticipatory bail is granted?
Then the correct thing would be to inform the court about it. Move an application before the court stating that we had filed for a bail application. I had voluntarily surrendered or given myself to the custody for the provision with regard to Section 27. of the Evidence Act. However, I was not treated correctly. That would have to be, you can file a Section 482 petition before the Honorable High Court, and that matter can be taken up.
Right. Advocate Sangriki wants to know the concept of limited custody.
So the concept of limited custody, in fact, there is a judgment of the Honorable Supreme Court which explains the entire concept. So what it states is that when a person surrenders willfully, only for, say for example, the police is saying that certain documents are to be recovered from an accused person. In that, so generally that is a defense that's taken by the investigating agency, that documents are to be recovered, sir, don't give them bail, or there are certain some offense, some weapon has to be recovered. So in such a case, the accused can voluntarily say that I surrender to the custody of the police, you conduct the investigation, and then the person is again released. So technically he would not be arrested, but he himself surrenders himself to custody. I will also just tell you the citation and the name of the judgment in this regard.
All right. Can we take more questions? Is it possible?
Yes. Yes.
Right.
It's State of UP versus Diyodman Upadhyay. This is the, in fact, CBO also talks in length about Section 27 with regard to limited custody, and the principle is stated by the court in the State of UP versus Diyodman Upadhyay. Hopefully that answers the question.
Now we'll move to the next question. It's by Mr. Himanshu Gupta. Are the status reports filed during the hearing of a bail to be shared with the petitioner? Should I repeat the question?
So generally they're not to be shared, but as a matter of practice, we do see the status reports. It is to be shared.
All right, that brings an end to our question session. We can hand it over to Ms. Siddhi Mittal now. Thank you so much for your insightful session. It is truly educational, and we are really, really thankful to you for your time and effort.
Thank you so much. Thank you so much for having me. Thank you, Nitesh, for organizing this, and thank you, Tanu, for coordinating it very well.
Ms. Siddhi Mittal, over to you.
Thank you, Tanu, ma'am. Good afternoon, ma'am. Everybody.
Good afternoon, Siddhi.
I would just like to conclude today's session, ma'am, by thanking you formally. Thank you so much. We really appreciate the time you took out for being with us and throwing light on this very important topic. It was altogether a very stimulating experience for all of us, because there are so many misconceptions and so many doubts we have, because this is such a normal practice of filing anticipatory bail in criminal law. So we're really grateful for your time, and we look forward that you give us an opportunity once again for having you on this platform, and so that you can share your views on another topic maybe.
Thank you so much, Siddhi. Thank you.
You're most welcome, ma'am. And I would also like to thank all the participants who took out time to join us. And last but not the least, NITESH MEHRA sir for organizing the entire webinar, and his entire team, Tanu ma'am, JYOTI ma'am, for being a part of it and helping this webinar be a success.
Thank you so much.
Thank you, Siddhi. And I think that without having the efforts of all of you, this wasn't possible. And Priyanka, thank you once again for taking out your time for this wonderful topic. I think conceptualizing anticipatory bail through the case study was a wonderful experience for all of us, and we all has gained a knowledge on the subject. Thank you so much, Priyanka. We'll soon like to see you.
Thank you, everybody who attended the webinar. Thank you so much, Nitesh, for organizing it. And thank you, Tanu, JYOTI, and Siddhi for being a part of it and coordinating it very, very well.
Thank you, ma'am.
Thank you, Priyanka.
Thank you, ma'am.
Thank you, everyone.